He is a real owner. And Mr. X is only a name lender who is called as a Benami. Now, just to highlight, a Benami arrangement is different from a typical trust arrangement, because in trust, what happens is the property is settled into a trust and the trustee is appointed. The trustee is the real legal owner of the property. However, the benefits from arising from the property are basically then given to a beneficiary. So when the trust is created, a beneficiary is identified, and the trustee holds the property in trust for the benefit of the beneficiary. So in the trust arrangement, the legal and the real owner is actually the trustee. However, he is obligated by virtue of the trust arrangement. He is acting in a fiduciary capacity, and he is supposed to apply the benefits to the beneficiary. Now, what is important to keep in mind is that historically, when these kind of transactions originally arose, these were not per se considered to be bad. A Benami arrangement, as we just discussed, was very much a legal arrangement. And in fact, courts were protecting such arrangement, and courts were protecting or upholding the interests of the beneficial owner. So the arrangement per se was not considered to be a bad one. More so that when there were situations where the Benami used to turn rogue and tried to take away the property, when the real owner tried to assert his rights, then the legislature introduced provisions in the Trust Act, Section 81 and 82, to legitimize and to provide legal backing to these transactions, and also to protect the interest. I'm sorry, are you able to see my screen? And
yes, sir, yes.
Yes, sir, we can see the screen, but it's not moving.
Oh, okay, because I'm
It's
sorry.
static.
Okay, because I am moving my slides, but probably just a minute. I'll stop. Just give me a minute. Go to slide 6. Yeah.
Now it is moving, sir.
Yeah. Next. Yeah. So I was mentioning that the arrangement was very much considered legal, and they also introduced changes in the Trust Act, Section 81 and 82, to provide legal backing and to protect the interest of the beneficial owner. Now, over a period of time, the Benami arrangement was misused, and it was used for circumventing certain legal provisions, where somebody could not hold a property or somebody could not do certain actions on their own. They started taking the Benami route. They started planting name lenders in order to carry out the transaction. So it defeated the underlying purpose of the law. Similarly, it was a very often used method to evade taxes or to sometimes defraud creditors, etc. Now, because of this background, almost after 100 years, it was decided that the Benami transactions should be prohibited, and in a way should be treated as a crime, and certain penal consequences should follow. So this was the evolution of the law. So after the initial phase where it was given legitimacy, then there was a law commission report based on which a ordinance was enacted initially to prohibit the transactions, and then it was converted into an act, and subsequently the amendments, as I was mentioning, in 2016 certain amendments were carried out, and now we have the amended law. We will just see what exactly the amendments were, etc., in a minute, but this is how the history of this particular law was. Now, So the 1988 Act, initially the ordinance, which was then converted into an act, it was a very, very, I would say, short piece of legislation containing only about 9 sections, 9 provisions. And it contained a very simplistic definition of Benami transaction, which basically talked about a tripartite arrangement, which is like the classical definition of Benami, where one person pays the consideration for acquisition of property, but the property itself is acquired in the name of the Benamidar. So that kind of a typical tripartite arrangement was covered. Also, the definition talked about the aspect of transfer of property, the aspect of holding of the property for the benefit of a beneficial owner was not covered initially. Similarly, the expanded meaning which we have today, which covers certain sham transactions or fictitious transactions, those provisions were also not there. So it was a very simplistic definition to start with. Also, it had a provision for acquisition of a Benami property by the government. So in case a transaction is declared Benami, the government had a right to acquire and eventually take away the property without paying any consideration. So it was like a compulsory acquisition, which was provided for. The exact modus operandi for acquiring the property was to be notified by way of rules, the exact procedure to be followed, which authority will carry out this function. All of it had to be notified by way of rules. It also provided for certain punishment for the Benamidars and the beneficial owners. Similarly, any recovery action by the beneficial owner against the Benamidar was barred. So that means a beneficial owner cannot assert his rights to claim title over the property which is otherwise with the Benamidar. So that kind of civil remedy was also barred. And this also repealed some of the existing provisions in different laws, especially Section 81 and 82, which I mentioned in the Trust Act. So effectively, it is like undoing what was done 100 years ago by taking away the legitimacy given to the Benami transactions. Now, this 1988 Act was there in the statute book for almost 30 years, but still it was like a dead piece of legislation, mainly for the reason that the rules which were required to be notified were never notified. And the reasoning behind that, why the rules were not notified, was that it was felt that the act was not fully equipped with certain provisions. There were certain gaps or infirmities in the existing piece of legislation, because of which it was felt that they could not fully give effect to the provisions. So the question came about that how to fill up this gap. So instead of notifying the rules under the existing piece of legislation, which would have again been subject to a lot of challenge, etc., they had two options. One, to completely scrap the 1988 Act and come up with a completely new piece of law. Another option was to amend, carry out necessary amendments to the existing Act and fill up all the gaps and then come up with a proper procedure. So the Ministry of Law was of the opinion that if they end up repealing the 88 Act and enacting a new Act, then there will be a problem in enforcing the law against earlier transactions. So any transaction happened, say, between 88 and 2016 could not be proceeded against under the new law, because it will be a new law, and Article 20 of the Constitution will bar any action being taken against a past transaction, because if the law has come into force now, it can't be retrospectively applied, especially in a situation like this where it is a criminal offense. So the law ministry recommended that instead amendments should be carried out, and they were of the view that the amendments which are being done are substantially procedures are being notified. apart from certain areas where the definition itself was getting expanded, etc., those were to be applied prospectively. But to the extent of the existing meaning of Benami transactions, the ministry felt that all the procedures which are now going to come as part of the act itself can be applied even for the past transactions. So that is again something which we will discuss whether the understanding was right or not. But this is the basis on which the 2016 amendments were carried out. Now, what exactly are the amendments which are there in the 2016 Amendment Act? So first of all, they provided proper definition for the Benamidar, beneficial owner, Benami property, etc. We will discuss these aspects a little bit in detail later. Just I'm giving an overview here. Further, as I said, the Benami transaction, which was earlier only taking care of the tripartite situation, is now expanded, and then they have added few more clauses. This again we will see it in bit detail. Also the property, what can constitute a property and what can constitute a Benami property, was given a slightly wider meaning. Similarly, the procedural aspects, the administrative aspects were also taken care of. They have now appointed the relevant authorities to implement this law, to carry out investigation, to carry out adjudication, to carry out other recovery functions, etc. So all of these, which was not there in the earlier law, is now taken care of, and now it has become a much more elaborate, a full-fledged, and to a large extent, I would say, self-contained piece of legislation. Now, this amendment, when it was done, first aspect we are going to discuss, which is a very, very, I would say, still a live issue, though there have been multiple rounds of litigation before Supreme Court. The issue is very much pending adjudication by Supreme Court, and therefore it's very relevant for us to discuss that. So there were different High Court judgments on when the 2016 amendment took place, and the law was being sort of enforced against various people. Most of the transactions they were targeting were transactions which have already happened before 2016. In some cases, the properties were continued to be held by the Benamida. So in a way, the transaction continued. In some cases, the transactions were already completed before 2016. So when the enforcement happened, the assessees argued that a law which has come in 2016, it cannot be applied retrospectively. The counter argument was, no, we are not applying the law retrospectively because the Benami law was already there and the definition of Benami was already there. So the transaction was always Benami. Post 2016, we have the enforcement powers and we are enforcing now. That's the argument which was taken by the department. So when the issue went to the Supreme Court held that pre-2016, whatever legislation was there, according to them, it was unconstitutional. So they struck down the earlier law as unconstitutional, though, interestingly, it was never an issue before the Supreme Court. Before the High Courts, it was not nobody had challenged the pre-2016 law. And even before Supreme Court, it was not an issue. But still, the Supreme Court gave this ruling. And then they said, therefore, even post 2016, by using these enforcement powers, you cannot target transactions which have taken place pre-16, because pre-16 there was no law according to them which can be invoked to hold them Benami. And you cannot use a post 2016 law to declare a pre-2016 transaction as Benami. So they ultimately held in the case of Ganpati Dilcom that wherever the department has invoked these powers for the prior transaction, those actions are not sustainable, and then they sort of decided the issue in favor of the taxpayers. Now, yeah. So now, once this ruling came, the effect was all over India, wherever these proceedings were initiated, and the assessees argued that any attachment, etc., which has happened is bad in law. And then the tribunal, the appellate tribunal in Delhi, decided, I would say, hundreds of appeals, if not thousands, en masse, holding that all these actions by the department is wrong. So they decided in favor of the taxpayer. However, when this ruling was given, at that time already the department had moved a review petition before Supreme Court, and the review petition was pending.
Sorry,
Yeah. So when this happened, so the review petition was already pending. So the tribunal said, we are now deciding the issue in favor of the taxpayers. However, subject to the outcome of the review petition before Supreme Court, we give liberty to the department to revive their matters by filing a restoration application if the review comes in their favor. So this was already one of the observations by the tribunal. So when it happened, subsequently, when the matter came up for review before a different bench, the Supreme Court of the view that the Supreme Court in a way crossed the line in the earlier round when they held the pre-2016 law as unconstitutional, because that was never an issue before them. So according to them, the earlier judgment had to be recalled and the matter was fixed for a fresh hearing. And also, the Supreme Court said that wherever the matters have been disposed of by relying upon the earlier Supreme Court judgment, post this review, the department will be at liberty to restore the matter back to the same position by filing petitions. Now, there's a very, very interesting wording given by the Supreme Court where they say the department is at liberty to file such restoration petitions. Now, they do not say per se that if such petitions are filed, then the appeals will be necessarily restored. So in a way, it's a very open kind of a remark. So the question came up that suppose like we have cases where, say, almost 1 year had passed after disposal of the appeal by the tribunal. And after 1 year, the department has been filing the restoration applications. So right now, the tribunal, as a matter of fact, has restored all the appeals of the department and for the assessee before them. However, interestingly, the Supreme Court itself, in some subsequent rulings, in the case of Kokila Bain and Virendra Amritbhai Patel, have held that the question of filing a restoration application or what we call as a ROM, rectification of mistake application, will have to be seen under the law, whether it is possible, what are the time limits, what are the conditions, etc. They said that merely the fact that subsequent ruling has come is not a ground for review. So there is a mistake of the mistake should be apparent on record on the day when the ruling was given. So on the day when the tribunal followed Ganpati Dealcom, the first judgment, they were right in doing so. The fact that subsequently Ganpati Dealcom itself was reviewed and the earlier order was recalled doesn't make the first round incorrect. So Supreme Court said that, in fact, when petitions were filed before Supreme Court to restore some of the SLPs dismissed by Supreme Court said nothing doing. They interpreted the Ganpati Dealcom review petition. In fact, they even went to the extent of saying the last line observation given in the review petition review judgment of Ganpati Dealcom, they even said that is per incurium. They said that is not correct. So effectively, Supreme Court itself said that the observation made by Supreme Court in the earlier case was incorrect. And then they said now whatever appeals have been disposed of cannot be restored. So today we are in a situation where hundreds of appeals relating to Benami matter are pending in different forums, especially the tribunal. There are hundreds of appeals. and the maintainability of those appeals, the act of restoration by the tribunal itself is a major subject matter of debate. And I'm sure this issue in the coming months and years is going to be debated before high courts and ultimately before Supreme Court. And today, according to me, going by the existing rulings by Supreme Court, most of the appeals should get decided in favor of the taxpayer by on the ground that the review was not correct. So this is where we are. I think the last 2-3 years we have seen a lot of action because of this back and forth which has happened in the Supreme Court, and this is still not concluded. Separately, the Supreme Court review petition did not say that the earlier law is constitutional. They did not get into the merits of that particular issue. They only said that without a ground being raised and without there being a list before them, the Supreme Court was incorrect in holding it unconstitutional. So today, even today, the point as to whether the earlier law was constitutional or not remains open. And in the near future, we can see a lot of action taking place on that aspect as well. Now, leaving aside all this past and then trying to see the law as it exists today, now the expanded definition of Benami transaction comprises of 4 limbs. The first limb, capital A of section 229, is something which was in a way already there with some amendment. But this A is what was already there even before 2016. B, C, and D are the so-called sham transactions which have got added later. So the first A limb is called a arrangement, tripartite arrangement, where there is a beneficial owner, there is a benamidar, and there is a third party which is buying, selling the property, etc. B, C, and D are basically situations where some kind of a sham transaction or a fictitious transaction take place, and that is also then categorized as a Benami transaction. Now, just spending a little bit of time on the definition. What is important here is when we talk about the tripartite arrangement, the 2 conditions, twin conditions, which need to be satisfied are that there is a property, and that property is either transferred to a person or it is held by a person. So the person here is basically referring to the benamidar. So if I am a beneficial owner, I transfer my property to a benamidar, or I effectively get the property transferred by some third party in the name of the benamidar, and the consideration for that is flowing from me. So the benamidar doesn't pay any consideration. I pay the consideration, but I get the property transferred and get the property held by the benamidar. And the second element, which is the addition to the definition, is that the benamidar must be holding the property for the immediate or future benefit of the person providing the consideration. That means the beneficial owner. Now, this is also very important because in many cases, it is not merely enough that just because I have paid a consideration, I become the beneficial owner, somebody else is the benamidar. It is important to also highlight that the so-called benamidar is holding the property for my benefit. That means he cannot enjoy the property. Basically, it is me who enjoys the property. And one more aspect is it need not be immediate benefit. So the definition talks about immediate or future. So for example, even if temporarily, let us say, the benamidar is enjoying the property. Let us say we talk about house property. Let us say the benamidar is living there. He is fully enjoying the property. But ultimately, it is for my benefit. He cannot sell the property, or tomorrow if he is going to sell the property, all the money is going to come to me, etc. So even if a future benefit is going to accrue to me, that is also good enough. Now, apart from this, that the tripartite arrangement, we will also see some exclusions which are there. Apart from this, when we talk about the other three clauses, those are the cases where the transaction is executed, but it is executed, say, in the name of a fictitious person. So let us say I show as if the property has been transferred to another person, but the transferee actually does not exist. He is a fictitious person. I use some fictitious names, and then I show as if I have transferred the property. Now, in the earlier definition, this transaction would not have been covered. So all the B, C, and D, the additions which have been made, they do not fall within the classical meaning of the Benami transaction as we saw originally. So these are all things which have been added under the new law to expand the scope of the law. And we will see the effect of it. We will see some examples where this can be used. Now, maybe I'll just request my colleague Mahinder to explain from the tripartite transaction, there are certain exclusions which have been given. So Mahinder, can you just explain what are those exclusions and where is it applies?
Sure. So, the third category is where the property is bought, say, by the HUF or any member of the HUF for benefit of the HUF or the members. There, the law deems that this is between the family members, and if it is established that the property has been acquired from the known sources of the HUF, then that transaction will not be considered as a Benami transaction. Similarly, where the properties are acquired in the name of those persons who are basically in a fiduciary capacity. So that may be a trustee or a partner of the firm, or say a director. In all these cases, where the law deems that the parties have a fiduciary basically relationship, in those cases also the transaction will not be considered as a Benami transaction. Third case is where the individual, he acquires the property in the name of, say, his wife or his children, and he is able to establish that the property has been acquired out of the known sources. We have seen that there was a recent ruling of the High Court of Delhi, wherein the High Court basically made a remark that a property acquired by the husband in the name of wife, that may be hit by the provisions of the Benami law. However, in that case, they did not see that this the exception is there, which says that if the husband or the spouse, say the wife acquires in the name of the husband, the spouse is able to show that the property was acquired out of the known sources. In that case, that transaction will be falling in the exception category, and it will not be hit by the Benami law. Similarly, the fourth exception is where it is in the name of sister or brother or the lineal ascendant or the descendant. In those cases also, and if it is the party is able to establish that the property was acquired out of the known sources, in these cases also the property will not qualify as a Benami property. So the essential element which the law here deems is that it must be acquired out of the known sources. And the specified category basically deal with those cases where we generally see that the family member may want to acquire some assets in the name of either the current family member or the next generation. So the law had basically provided for the exception that these cases will not be considered as Benami transaction.
Sir, can we ask a query? Sir, can we go ahead with the query?
Yeah, please.
Sir, in our city, there used to be some colony around 100 acres. the department got some inspection at some client and some people, and they just got to know that the whole colony is, as per their version, is under Benami. The person has acquired the 100 acres of land, semi-urban land under different names. The department started issuing eviction notices to various residents of the developed colony. So the matter is now prejudicial with the higher authorities and courts also. But my question is whether department can directly declare anything to be Benamis just on the basis of chips or some paper or chips find on behalf of someone else search and give an eviction notice to the residents of the colony. Although residents are abiding by every taxation of the local authority, be it the property tax or the electricity bill or anything. The department is on the plea that they have discovered document around 40 years old, and this property is originally under Benami law. The question is, the Benami law being notified in 2016-17. How could the people recognize it to the 30-40 years old thing and take a plea that it could be the under this Benami law? Please, sir, please elaborate on this issue on a small thing rather.
Yeah, sure. I think the way you explain the facts, definitely this is a typical case where the validity of the earlier law and the interplay between the earlier law and the current law, whether the current law can be invoked to declare a old transaction, 40-year-old transaction, as you said, to be Benami. I think this is a classic kind of a case where this point will be debated. And according to me, there are sound reasons on which
It's like section 2 says cost to the previous owner under capital gain. The people are treating the same thing then under Benami, that who is whether the owner on the first chance or who has got the property registered done as the title deed on the first time. So they are not recognizing the current owners under resale. They are recognizing the old people who were owners at the 30 or 40 years ago to be the Benami thing, just for correlating with the search process.
No, I'm just saying that what is very important, because I'm not fully clear about the underlying facts, but I'm just pointing out one thing, that as a legal argument, if the alleged Benami transaction has taken place 40 years ago, and I also assume the people who are currently residing in that colony and who are claiming to be the current owners of those properties, I understand that they are all what we call as a bona fide purchasers. That is, they have nothing to do with the alleged Benami transaction, is what I am presuming. So apart from the legal argument on the whether the earlier transaction can be subjected to some kind of a proceeding post 2016, also there is a concept of bona fide purchaser, which we will be discussing in some time. So according to me, if we can show that all these people satisfy the ingredients of being a bona fide purchaser, then there is a protection which is given under the law. So even if the department were to declare some earlier past transaction as Benami, all the bona fide purchasers may still be able to get relief. So that is something which we will discuss. So according to me, on multiple grounds, we should be able to defend it. And to answer your point as to whether the department can just like that declare a transaction to be Benami or a property to be Benami, obviously the answer is no, and there is a very elaborate procedure which has been prescribed. Now, what may happen is that after the initial investigation, there is a provisional attachment which happens, which is then subjected to adjudication. So there is an elaborate process of adjudication which happens. There is a proper show cause notice where all the impacted parties, not only the Benami dar and the beneficial owner, But let us say there are other people who have acquired interest in those properties. Like in your case, there are so many people who are claiming to be the owners today. Even those will have an opportunity to be heard by the adjudicating authority, and all their interests will have to be decided. So according to me, as a first reaction to what you are saying, on multiple grounds, according to me, this kind of a thing can be challenged. And we may have to get into the exact reason or exact transaction, which according to the department makes it Benami. But whatever I heard and whatever I could understand, I think we do have the bona fide purchasers here do have a strong case. That's what I can say.
No, sir, proceed with your next presentation.
Yeah. Now, what we intend to do is, having seen the history and having seen the essence of what constitutes a Benami transaction, we have taken certain case studies. Now, the primary purpose of these case studies, now all these case studies are live examples. Either they are based on decided cases, or they are based on certain ongoing cases where actually the department has alleged a Benami transaction. What we want to highlight is, it is not only the classical transaction of Benami, which is sought to be targeted here. We will see how certain transactions which are undertaken in the normal course of business, which I'm sure as professionals we would have come across many times, and how the tax department, apart from doing whatever they can potentially do under the tax laws, are also invoking the Benami law. Now, as you can imagine, the powers under the Benami law are much more, I would say, draconian in terms of what they can do to the property, the attachment, the eventual confiscation and all that. And apart from that, there is also a criminal prosecution angle which comes in. So therefore, handling some issue as a tax dispute is one thing, but the moment it takes the color of a Benami transaction, then a lot more serious consequences can come in. So these are few examples where we can see that how nowadays it has become a trend to invoke the Benami transactions. In fact, I can say that many times the tax officers are using this as a threat, that when we go and are handling a tax proceeding before them, they do sort of come up with this argument that I can potentially invoke Benami proceeding, and then you will have to face much more serious consequences. So these are some examples where Benami is getting invoked. So first case study that we are taking up is a situation where, let us say, there is company A, and the company A is interested in basically setting up a new, let us say, manufacturing unit in a particular location for carrying on the business. Now, it could be that, let us say, a company A is engaged in manufacture of, let us say, phones, and they are interested in now setting up a unit for manufacture of batteries in a particular industrial area. Now, the regulatory laws are such that in that industrial area, if company A is already been allotted a land and it has already been operating a particular unit, say they are not allowed to take one more piece of land and set up one more unit. There are some regulatory restrictions there. So what company A does is that they basically ask some of their senior employees to set up a new company, company B. The employees invest capital, like a nominal capital, say a few lakh rupees, and then establish company B. And then company A enters into financial transactions with company B. Say, for example, it could be by way of loan, it could be by way of debentures. So officially, legitimately, company A and company B have certain financial arrangements. And then the company B then applies for the allotment of land, gets the land, and also sets up the battery unit. And this arrangement then goes on. Now, here in this arrangement, the tax department says that the land which is owned and possessed by company B is actually a Benami property. Company A is the beneficial owner of this property, and the land is held Benami for them. Either they can say company B is the Benamidar if they are targeting the land, or they can, if they are targeting the shares of company B, then they can potentially say that the employee who is acting as the shareholder, he is actually holding those shares for the benefit of company A. This is a live example which I am taking, where the matter is still sub judice and it is happening. Now, when we look at it, it is like, as far as the company is concerned, they say we have undertaken a very legitimate transaction. Everything is on paper. Every money that I have paid is legitimately transferred by either by accounting for it as a loan or as a debenture, etc. The shares which are held by the employee. Now, what is the critical aspect over here is the shares which are held by the employee. In what capacity they are holding those shares? Are they holding the shares in their independent capacity, or they are like a nominee, they are like a name lender, where they merely act as puppets as directed by company? I think this is the critical aspect. If the company is able to demonstrate that this arrangement was done basically to comply with the regulatory laws and to carry on the business in a legitimate manner, and the employee who is holding the shares of company B have invested their own money and they are holding it in their own right, if this is possible, because I took the example of employee here. In certain cases, it could be a family member of the promoter of A, where say a brother or a nephew, somebody could be there, and it is very common in Indian businesses. Sometimes this is very common. So whether this arrangement can be treated as a Benami is a question, and according to me, there is a very, very thin line of difference. I think if the documentation is properly maintained, if the independence of the shareholding in company B we can demonstrate, also the source of money from which that company B is established, etc., can be demonstrated. Also, the financial transactions between company A and company B also needs to be properly explained, and it should be demonstrated that there is a commercial substance behind it. Based on that, one can definitely defend these things. But interestingly, more and more such cases are cropping up, which is a legitimate business transaction being colored as a Benami transaction. Now, one more aspect over here is that when company A provides a loan to company B, there is a liability for company B to return that loan. It is not only shown on the books, but it's a real liability which exists, maybe with interest, without interest, that can be there. So when the section says that the property is acquired and the consideration for the property is paid by the beneficial owner, in this example, the consideration is actually paid by company B to the landowner when the land is acquired. The funds, the source of the funds may be a loan taken by company A. It could be from company A, it could be from a bank also in another case. So just because the loan has come from company A doesn't mean the consideration has flowed from company A. I think that's the finer distinction also, which will have to be demonstrated here. Now, Next case study, which we wanted to take, Mahinder, maybe
Yeah.
do you want to explain this? Yeah.
So, sir, in this case, what is basically happening is that the promoters, they want to take out some money from the company. And for this purposes, they take assistance of their consultant, and bogus invoices are raised on the company, and the money is paid as payment for supply of goods and services. In reality, there is no supply as such. And basically, after multiple layers, the amount reaches the promoter in cash. Now, these are those transactions which we generally see as bogus transaction, which may be subject to the penal provisions under GST law or under the income tax law. We have been seeing that now these transactions have also been taken for investigation by the department under the Benami law. Now, here the argument of the department is that there was no actual supply as such. The money transferred from the company and then held in the bank account of the other company, they are calling that amount or the bank balance as the property held by those company on behalf of the promoters. So those who are holding the money in their bank account, they are being labeled as the Benamidar. The promoters are being labeled as the beneficial owner, and that the money in the account is being alleged as the Benami property, and equivalent to those funds in their banks, they are those amounts are basically being attached by the department. So these are the latest basically cases which we are seeing, where the department has started investigation under the Benami law also. So though as such, though a counter argument may be raised that a cash does not qualify as a Benami property, and it is not a case that I am or that the beneficial owner has paid any consideration for acquiring that money as a Benami property. All these arguments are there. The purpose of highlighting this is to give that insight that even in these cases, the department had started the investigation.
And also, just to supplement what you said, it's not only that the department is viewing a bank deposit which is kept in the bank itself as a property, but even the tribunal in various cases has said that such amounts can also qualify as property. So this really gives a much wider meaning to the Benami transaction. So again, the overreach by the department is what we are able to see here.
Excuse me, sir. May I ask, what is the view of yours, sir, kindly, कि ऐसे केसेस में क्या मतलब रहेगा, एक probability क्या रहेगी?
Sir, now, as I said, just Mahinder, if you can go back to the definition of Benami, we'll just test it against the definition of Benami definition here. Now, as far as clause A is concerned, clause A requires that there must be a property. That property is transferred to or held by. So the first question is, what is property? Whether the money which is paid by the company to the vendor for, within quotes, purchase of goods or services, and then the vendor is now, say, holding it in a bank account. Whether that money itself can qualify as property, that is one argument according to me. The way the section is worded, the property here cannot mean the bank deposit itself in the transaction of this nature. Second, for this transfer of money, there must be a consideration, which consideration is paid by the beneficial owner. So the section talks about property and consideration as two different things. Here, there is only one transaction of movement of money which is happening. I'm assuming the department is right in saying that there is no underlying sale of goods or provision of services. So what has happened? The money has moved from the company to the vendor, and the vendor is now holding on to the money. So therefore, the first limb of the definition, which talks about there being a property and there being consideration for property, that is not at all getting satisfied. So according to me, clause A will not apply at all here. Now, when we talk about clause B, C, and D, now B talks about where there is a fictitious name and the property is sort of the transacted in that fictitious name. That is not the case here. Here, the company exists, the vendor also exists. There is nobody which is fictitious. Similarly, in clause C, it talks about a transaction or arrangement where the owner of the property is not aware of or denies knowledge of such ownership. Now, in a situation which we discussed, the vendor is claiming that he has received this money for provision of goods and services. And as far as the money which is held is concerned, he is not denying or he is not saying that he is not the owner of this money. Nobody else is also denying the ownership over the money which they hold. So in a situation like this, clause C is also cannot be invoked. Clause D talks about a situation where the person cannot be traced. That is, the property has come, but who has paid the consideration? That person is not traceable. That is also not the case here. So if we dissect the definition and then look at each limb, I think in a situation like this, it may have other consequences. It may have consequences under the GST law. It may have consequences under the income tax law. All that is on one side. But even assuming the facts to be correct, this may not satisfy the ingredients of the Benami law.
Right.
That is my view. But again, these are the things where we are seeing that, as I said, the overreach, and then after having made out a case under income tax, there is also a tendency to expand it and then make it into a Benami case over here.
Right, sir. Right. Right, sir. Thank you. Kindly proceed, sir.
Yes. Now, the third case study, now again, this is a live example and I would say much more refined here. Now, what happens is there is a company and that company is held by Mr. A. He is the shareholder of the company. And Mr. B comes into picture. Let us say that before Mr. B acquires the shares of this company, Mr. B gives loan to the company. So the money has now come to the company and it is sitting as a loan taken by the company. With that money, the company then purchases a land. And let us say for 6 months, this arrangement continues where company is owning the land, company is having a loan liability towards Mr. B. The shares of company are held by Mr. A. This arrangement continues for 6 months. After 6 months, what happens is Mr. A then decides to transfer shares of this company to Mr. B. And let us say that the transfer happens at a somewhat nominal value. Now, post this transfer, Mr. B has become the shareholder of company and company continues to hold the land. So that as far as the ownership of the land is concerned, it was acquired by the company and it is with the company. Now, in arrangement like this, the department has come up with a case that Mr. B was the beneficial owner of this land and Mr. A was actually Mr. A and the company. They have named both of them as Benamis, as holding the land for the benefit of Mr. B. And then they say the loan which is given by Mr. B is the consideration for the acquisition of the land. Now, many times we have seen that the reason why this happens, like in the case which I am talking about, actually the reason was that there were certain procedural formalities to be completed before Mr. A could transfer the shares to Mr. B. Always the intention was that ultimately Mr. B will become the shareholder. There's no doubt about that. But due to certain procedural, I would say, delays, the transaction of transfer of shares takes some time. But in the interest of the business, the parties agree that the company should go ahead and acquire the land, and for that the funds are provided in the form of a loan. So it's all done for legitimate reasons, all documented. But if you read the provision in a literal sense and then try to apply to this, it can potentially appear to be a Benami transaction. So it's very important that, like, what we are experiencing is that many times when these transactions are undertaken, how the parties document the arrangement, how the parties document their intention of undertaking these transactions, and kind of keeping a proper record of this is always helpful. Now, not necessarily this is a case where Mr. B is trying to circumvent a law, or Mr. B here is trying to evade taxes by carrying out a transaction in this particular manner. Not necessary. So if those kind of cases are there, then a proper, I would say, documentation right from the beginning, contemporaneously. Many times what happens, the transactions are carried out. At that time, the people work based on trust, and then they don't document things. But subsequently, when an issue like this crops up, then you have to depend on some affidavits and some kind of a confirmation, declaration, etc., being given by the parties, etc., which kind of reduces the evidentiary value. So all these things, if they are contemporaneously documented, that's what we have seen in our experience, definitely helps in avoiding a Benami situation. Yeah. Now, this is another issue which is coming up quite a lot, and there are many cases which you will be seeing on these lines. Now, say that there is a so-called Benami transaction, tripartite sort of a transaction, which has happened pre-2016. Now, the property was acquired, and it is now, say, in 2015, the property was acquired in the name of the Benamidar. The consideration was paid by the beneficial owner. So the acquisition per se happened pre-2016. Now, the Benamidar continues to hold the property even post-2016. Let us say in 2018, after the amendment has taken place, the authorities come and then issue a notice, and ultimately they hold that this is a Benami transaction and so is Benamidar and so is beneficial owner. Now the question is, if the transaction has, the acquisition has taken place, the consideration has been paid before 2016, before the amendment, can the provisions be invoked? Now, one aspect, again, Mahinder, if you can go back to the definition. Yeah. Like I had mentioned that I said I will come back to this point. Earlier, if you see the pre-2016 definition of Benami, it did not have this highlighted portion. So it said where a property is transferred to a person and the consideration for such property has been provided by some other person. So that means the aspect which was treated as Benami transaction was the aspect of transfer. Now, in our example, the transfer of the property took place in 2015. Therefore, one can potentially argue, now I am assuming that the law is supposed to be applied prospectively only from 2016 onwards. That is, Ganpati Dealcom, the original judgment is correct, and then let us say we proceed on that basis. So the question is that even though the transfer took place earlier, the second element of holding the property. So the Benamidar continues to hold the property even post 2016. So can the department allege that for invoking the new law, I have to only demonstrate that the Benami transaction as vis-a-vis holding is continuing and it exists even post 2016. Therefore, this law can be invoked. Now, this argument has actually been taken by the department in various cases. These issues are pending at different levels. And one of the views, now, if you ask me, definitely an argument is possible that the word transfer and held here are used in two different contexts. One is a situation that the example which we discussed, the case study, going back to the case study. In this case study, it is a situation where the property from a seller, from a third party, was transferred to the Benamidar, the alleged Benamidar. That is covered by the first limb of transfer. And that has taken place pre-2016. The second limb in the definition which talks about holding will cover a situation where there is no transfer otherwise. But as I said, suppose a property which is belonging to me, I hand it over to Mahinder and ask him to hold it Benami for me. So there is no actual transfer between me and Mahinder. It's just that I hand over the property to Mahinder and Mahinder is holding. We have to keep in mind that the property here could be many things. It could be immoved property, it could be moved property, it could be so many things. So the aspect of holding should come in a situation where even without a transfer, the Benamidar comes into existence and he is holding that. Similarly, there can be situations involving shares where the shares are not transferred, but the shares are issued first time to somebody and those shares are held Benami for somebody else. So according to me, this argument of the department or the way they are looking at the term hold does not appear to be correct. So in an example like this, where the underlying transaction has already taken place pre-2016, according to me, the argument of retrospective applicability of this law will definitely arise. And eventually, to my mind, we should be able to succeed before the higher courts. Now, there are few more aspects we wanted to highlight, and then we can take up the questions which we have. What happens now? We have discussed so much about Benami and in what circumstances it can be held Benami, etc. Now, what are the consequences of a transaction being declared Benami? Now, there are two broad buckets. One is a civil liability and other is a criminal liability. Now, on the civil side, basically the property in question can be attached by the department. Ultimately, the property can be confiscated and taken away. So that is the civil consequence, and bulk of the disputes, bulk of the work happens on this, where the matters travel to the tribunal and all that. We will come to those authorities there. The second possibility is that there is a punishment which is there for the Benamidar, for the beneficial owner, and for any other person who abets such Benami transaction. So there is a criminal prosecution which can be initiated, and there will be a trial before a special court, and eventually there can be imprisonment, fine, and all those things. So what is important to keep in mind is not only the Benamidar and the beneficial owner, but even any other person who has abetted or facilitated these transactions with the knowledge that he is facilitating a Benami transaction, even those people are liable to be prosecuted. Now, which are the authorities which we need to just bear in mind and their broad functions? Now, typically, you have a initiating officer. Now, first and foremost, as we know, this Benami law, the administration is by the same income tax department, and they have the separate wing which also takes care of the Benami transactions there. So there is an initiating officer, who is like a investigating officer who conducts all the inquiry, the initial investigation, etc. And then at a given point of time where he has the reasons to believe that certain Benami transaction has taken place, then he has powers to provisionally attach the properties, and then he has to then refer the case to the adjudicating authority while giving notice to the concerned parties, the Benamidar, beneficial owner, or anybody else who may be having interest in the property. And these actions of the initiating officer are approved by a senior officer who is called as the approving authority. And then there is a separate adjudicator, adjudicating authority, which is there, which currently functions in some of the major cities, including Delhi, Bombay, Calcutta, etc. So these adjudicating authority is supposed to be like a neutral adjudicator where the case is referred, and then they issue notice to the alleged Benamidar, beneficial owner. They hear both the sides and then finally adjudicate the matter. Now, thereafter, once the order is passed confirming the attachment, then the case goes in appeal, and then we have the appellate tribunal, which is located in Delhi, which hears all the appeals, either from the assessee side or from the department side. Now, apart from this, as I mentioned about the criminal prosecution, that goes on before a special court, which is like a trial court, and that is a separate action. So, in many of the cases, even though the attachment would have happened and the case has already moved to the tribunal, we have seen that it takes much longer for them to initiate the criminal prosecution and do it. So, need not be synchronized that way. Now, apart from this, there are 2-3 specific issues we wanted to also highlight. Now, we talked about what constitutes a Benami property. Now, the definition of property, as I mentioned, has been widened under the new law to cover a converted form of property. That is, one, say in our earlier example, if there is a land which has been purchased and in the name of the Benamidar. Now, tomorrow, if that land is sold and that money is used, let us say, to buy gold. So even that converted form continues to be a Benami property. It's not only the land which is Benami property, but even the gold will be treated as Benami property. Similarly, any proceeds, that is, if it is converted into cash, and then say, even if it is lying in the bank accounts, those funds, that money also will qualify as a Benami property. So the definition is very wide. Now, I'm sure many of us would have also handled cases under PMLA. So just to draw a few comparisons between these two laws. In PMLA, there is a concept of value equivalent. So there is a concept of proceeds of crime and there is a concept of value equivalent, which means that if the department, the ED investigates and then finds that the proceeds of crime have come to me, but they are not able to exactly locate the form in which those proceeds of crime are held, then the law empowers them to attach what is called as a value equivalent. That is, if they have assessed that proceeds of crime worth, say, 1 crore has come to me, they can attach any asset from my possession which is of equivalent value. Now, which also means that there are cases in PMLA where I have acquired a property, let us say 10 years before the alleged scheduled crime has been committed. That means even before the crime occurred, much before the proceeds of crime came into existence, I have acquired a property, a 10-year-old property. But by invoking the value equivalent concept, even that property can be attached by the ED when it comes to PMLA. But what is important to notice when it comes to Benami, Benami law talks about the very property which is Benami, or the converted form of the property, or the proceeds from the property. So here there is no concept of value equivalent. So it's much more narrower, I would say, as compared to a PMLA provision. Therefore, the onus will be on the department always to show that how the property which is sought to be attached is either the Benami property itself, or how it is a converted form of the property. They can't simply say, I'm going to attach something of an equivalent value. That I think distinction we have to bear in mind. Similarly, I think one of the questions which came about was regarding a situation where there is a bona fide purchaser. Now, the law does protect the interest of a bona fide purchaser. So what it means is that if a property is acquired by a bona fide purchaser, before a show cause notice is issued under 24(1). Now, 24(1) is a section under which the initiating officer, who has some material to believe that there is a Benami transaction, there is a Benami property, he issues a notice to the Benamidar, to the beneficial owner, saying why the transaction should not be treated as Benami. That is the first time a formal notice is issued outlining which transaction is sought to be treated as Benami and which is the Benami property. So if any transaction has taken place before this notice and the bona fide purchaser, obviously because he is bona fide, he doesn't have any knowledge about the so-called Benami arrangement, then such bona fide purchasers are protected. That means if they are able to come and demonstrate this, then such properties will not be attached and it will be given back to the bona fide purchaser. So this is the protection which is available in law. Then the third aspect which we wanted to highlight is that this is very important because many times we have seen this happening. Now let us say that initially when the case is framed, when the show cause notice is issued, there is a particular property which is identified as Benami property, particular person is the Benamidar, and a particular person is beneficial owner. The investigation is ongoing, but still the attachment has taken place. The case is also referred to the adjudicating authority. Now the adjudicating authority has certain powers. One is they can look into the reference made to them, decide whether it is right, wrong, and accordingly they can confirm or they can decide to set aside the attachment, etc. But importantly, they also have certain powers to, in a way, enhance the scope of the reference. Now, so one power is to add more properties. That is, if say one piece of land was alleged to be the Benami property, but while adjudicating the case, while looking into the documents, while examining the witnesses, so many things may happen before the adjudicating authority. Suppose they come to know that apart from this land, there is some other property which is also a Benami property, which is linked with the same Benami transaction. They have powers to include that also as a Benami property. Similarly, if they feel that there are certain other persons who have to be also included as a noticee in the proceedings because their interests may be involved, etc., they can also add those people they can issue notice to those people and they can include them. Now, why I wanted to highlight this is we have come across cases where having made a case initially, and when the adjudication is taking place, when the assessee comes and then argues, the department realizes that their case is not likely to stand, or they have committed some very grave mistake in identifying the property or in identifying the Benamidar, etc. They then file an application before the adjudicating authority, and then they say that you using the powers under 26.5 and 26.6 make a totally new property as a Benami property, and even a totally new person as a Benamidar, in some cases even as a beneficial owner. So it's like completely changing the underlying reference, and then they are making a request to the adjudicating authority to completely make a new case. Now that is where a very interesting point comes, that whether the powers under 26.5 and 26.5 and 26.6 can be read so widely to mean that the adjudicating authority, instead of playing the role of an adjudicator, will now wear the hat of an investigator, wear the hat of an initiating officer, and come up with a completely new reference. They are completely changing the underlying reference. That, according to us, in fact, we are arguing these kind of cases in some matters, where, according to us, the powers under 26.5 and 26.6 are quite limited, and it has to be read in a proper context. That the underlying reference should continue to be the same. The reference per se will not undergo a change, but it's like you can add on to the reference. You can add some property which has got left out, or you can add some person who might have got left out. But if the underlying reference is found to be incorrect, if the base is wrong, then I think you cannot completely change the case before the adjudicating authority. I think as income tax practitioners, I'm sure all of you are very much aware of these kind of arguments, which typically we also come across in the context of reassessments and search and all that. So this is again another interesting aspect which we are seeing, that I would say creative thinking on the part of the department to try and somehow make their case survive before the adjudicating authority. I think broadly, these are the aspects which we wanted to highlight from our side. We are happy to take questions. I can see that there are a few questions which are already there in the chat box. We'll be happy if people want to unmute and ask questions here.
Yes, sir. Yes. Thank you. Thank you, Vasudevan. Our convener, sir, CR Jain ji, is not good at health today. So I will help it out to take the query session with you. फर्स्टली सर, जो आपके लास्ट पॉइंट अभी हमने क्लोज किया है, उसमें ही मैं पूछना चाहूंगा कि वेदर द डिपार्टमेंट में कम विद ए फ्रेश केस फ्रॉम द वेरी इनिशियल लेवल.
Yes,
that is always possible. That is always possible. That is now. Firstly, I will go by the queries in the chat box. Then any member may raise his hands and put a query. So first query, sir, it is indeed of mine. Rather, you have already address this by putting some examples of bogus transactions, cash transfers, loan by company A to company B. But even then, we wish to know in little detail that what is the approach of the central government in the coming times, how this Benami Act is going to apply in the daily transactions, which can touch us more closely. एनी प्रोफेशनल. तो ऐसी कुछ एग्जांपल्स आपने परसीव कर पाए हैं आप कि उसमें क्या रहेगा आने वाले दिनों में?
सर, आई थिंक दो चीजें. एक तो गणपति डील कॉम का जहां तक सवाल है, जैसे हमने पहले भी बात किया था कि वो अभी उसमें एक जो लिटिगेशन है वो अभी खत्म नहीं हुआ है. एक तरीके से वो अभी स्टार्ट हुआ है. मैं कहूँगा कि अभी उसमें बहुत कुछ उसमें भी होना बाकी है. एंड दो एट प्रेजेंट it seems that the department has succeeded in reviving the past cases, but I think very soon we are going to see some authoritative pronouncements on it from the High Court. Already Supreme Court, as I said, in a couple of cases they have made some observations. So we are going to see another round of battle on that. So that is one aspect. As far as the approach of the department is concerned, I think the reason why I took these examples is to show that not only a outright case of Benami, but even something which is done with a good intent, with a proper legitimate for a business reason, even those can be viewed with jaundice eye. I would say that a department, when they look at it, they can try and see some element of Benami over there. So more and more, I must say that more and more we are seeing where out of nowhere the tax department then picks up or alleges an aspect of Benami. Like some of the examples which we discussed. Apart from that, for example, we have this case of these many of the insurance companies, which I'm sure some of you might have handled it, where the insurance company is having transactions with the insurance brokers and other intermediaries, and they are supposed to pay certain remuneration, commission, etc. Now, one of the allegation is that under the erstwhile law, the amount of commission that they can pay is capped, and these people are paying over and above that. That extra amount sometimes is paid in the form of a service fee. So they say that you are providing certain marketing services, you are providing certain promotional services, etc. So various ways that remuneration is paid. Now, from a tax standpoint, all of it has been offered to tax. There is no, whether from a GST standpoint or from an income tax standpoint, all these amounts are subjected to tax. Nobody is trying to evade any taxes here. So there have been attempts to make GST cases out of it. If not GST, I will impose penalty. There have been cases under income tax. Again, they are finding it difficult to somehow come up with a case because many other people have already offered these amounts to tax. Then they say that I will bring in the element of Benami. Why? Because there is an entity which is like a sister concern of the broking entity, and those entities have provided certain marketing services. Now, many times what happens, the broking entity cannot provide certain value-add services. So they typically have a group entity which is providing these services. They house certain employees there, and those employees provide those services. And the amount is paid to that sister concern. They say the sister concern, when they are receiving these amounts, are actually holding this money as a Benami amount for the broking entity. And then they are trying to invoke aspect of Benami. Now, this is a case where probably their case on the tax front is somewhat weak. So to cover it up, they are bringing in the element of Benami and then trying to attach the money. So I think what we are going to see going forward is more and more invocation. I think even from the department standpoint, they are also in a learning phase. They are also testing waters. They are also seeing how much they can push the line and try and bring more and more into the aspect of Benami. Because once you give the powers to them, I think it is quite natural that they will try to exercise those powers and show what exactly they can do. Many of them may be genuinely believing. Many of them could be just to harass the taxpayers, etc. But at least in our experience, we are seeing more and more invocation of Benami law in a normal tax disputes also.
We apprehend that from this point of view, the bogus nature of transactions, they are almost touching all type of bogus transactions, bogus nature of transactions. Right, sir? Moving ahead, sir, the next query is of CS Bajanji. He is putting that in section 2, subsection 9, what is the meaning of provided or paid? I think so. He's touching just like loan transaction type. Anyhow, kindly, Subhash ji, आप अगर कुछ इसमें elaborate करना चाहते हैं अपनी query को kindly.
So this provided gives a very wider meaning to the amount of consideration. If it is paid, then some banking channel, some cash is involved. Provider
Right.
means anybody who has given the money will be considered to be a Benami, maybe it loan, maybe anything other than that.
So, sir, we have to read this term paid or provided with the term consideration. So, what it basically means is it can be paid, say, directly by the beneficial owner, or it can also be paid through the Benamidar. So, either paid or provided directly or indirectly, and it should be payment of the consideration. So there is a fine distinction between payment of a consideration and granting a loan. So here there are evidence to establish that the loan was basically a facade, and all the documentation and the entire arrangement was made in a way to show it as a loan, but in fact it was a consideration paid or provided by the beneficial owner. In that case, the department may have a case to say that it is actually a consideration paid or provided. However, in those cases which are basically genuine cases, and the relationship between the party is basically a lender and a borrower, those transactions will not be covered here.
And also, sir, to add one more situation, as you pointed out, we have seen where department is invoking this provided. They say, if suppose the consideration is in kind. Now, the example which I took, where some of the people were providing some services to the insurance company, and in return they were getting this commission. Now they say one person performs the service, whereas the payment is made to another person. So the consideration here is not paid, it is provided in the form of a service. This is the allegation. But according to us, we are fighting that those kind of cases as well, where according to us, the definition is not capable of accommodating a consideration in kind. The consideration here, because it's used opposite to a property. So there is a property and there is a consideration for that. So in our interpretation, it should always be a monetary consideration that they are talking about, not some consideration in kind.
Consideration in the form of for the purchase of consideration in kind part of property.
Yeah, that is how department wants to read it. But in our opinion, maybe that interpretation may not be right. The consideration here has to be in some monetary form.
But in any case, provided connotes a wider meaning, I think.
Correct. Wider, like what Mahinder explained.
It
could be situation.
Any and every transaction.
Correct.
Sir, I must add that in genuine cases, if the department comes up with a provided plea, then I think so they may not be able to prove the second limb, the small b of the capital B A. So in such cases which are otherwise genuine, even if they have stick by the word provided, then they will not be able to prove the second limb in the very transaction. यहाँ पे sir, I have a good Supreme Court judgment wherein the paid and provided has been differentiated very elaborately. That is 4 SCC 243 1999, sir. So it is also has been deliberately discussed. Now I am coming to the next query, which is of our Vice President CA Sanjeev Pandhari ji. In case of property held by siblings in joint name from known sources, is there any percentage share limit for joint owners? Example 50-50 or even small percentage of 5% is also allowed. Pandhari ji, अगर आप कुछ elaboration देना चाहें, kindly.
No percentage had been specified in the law.
So it could
Right,
be
sir.
any.
It could be any percentage.
Next query is again of CA Sanjeev Pandhari ji. Suppose A buys a house and consideration is paid by B for immediate future benefits, but only in cash. All registration like property tax, electricity are in the name of A, and A who receives rent from such property in books, whether such property can be challenged by department as Benami. Over to you, sir.
Sir, like what I understand is the immediate benefit, that is in the form of rent, etc., is received by the alleged Benamidar. That is A here.
Right.
But let us say there are other documents and other evidences to show that the property is held by A for the ultimate benefit of B. That means, suppose eventually when the property is going to be sold, etc., the money will flow to B. That is the understanding.
Yes.
If that is the case, as I was mentioning, the definition accommodates both. It could be immediate benefit or a future benefit. So this will be a case of a future benefit, which is for the party which has paid the consideration. According to me, this can potentially fit into the definition, the first limb of Benami transaction.
Right, sir. Thank you. The next query, sir. A word abettor is used in prosecution proceedings. Kindly explain whether real estate advisors who facilitate property investment deals are covered under the abettor.
Sir, I think the word abatement is a very often used term in the criminal law. That is, when we talk about IPC, there is good amount of jurisprudence as to whichever provision talks about abatement, what constitutes abatement. There is a good amount of jurisprudence, and that will apply here, because this is, here also we are talking about a criminal provision here. So a mere involvement in a transaction may not be good enough to constitute abatement. I think what we say is there must be an active sort of a participation with the knowledge that what is happening is this, and then I kind of help them out in carrying out transaction or in hiding the Benami aspect of the transaction.
Sir, I may add something.
Yes, sir, please.
Actually, apart from real estate, some more issues are there because in case of business takeover or merger, we as facilitator help. In case of NPA accounts, we as help in taking over the business.
Sir, I think
Unmute कीजिए.
हरी जी, हेलो,
भंडारी जी unmute कीजिए kindly.
अनम्यूट करो.
हेलो
जी. Now, sir.
सर, इन केस उसमें क्या है सर, जो पहली पार्टी है उसका अकाउंट एनपीए हो गया, वो अपने नेम पे बाय नहीं कर सकता, ठीक है, बिजनेस, तो वो अपने किसी रिलेटिव सिबलिंग्स के नाम पे या फिर ये कह लो कि अपने एम्प्लॉयज के नाम पे ट्रांजैक्शन कर लेता है, चाहे उसकी अपनी प्रॉपर्टी हो, एनपीए में चली गई हो, उसने रीप से परचेज करनी हो या बिजनेस, तो कंसिडरेशन ही पेड बाय द फर्स्ट पर्सन, तो उसमें वी एज ए फैसिलिटेटर उसको हेल्प करते हैं, ठीक है सर, उसमें क्या रोल है हमें तो नहीं पता होता, या रियल एस्टेट ट्रांजैक्शन में भी हमें नॉलेज नहीं होती है, तो उस केस में हमारा रोल क्या लिमिटेड है या वी कैन आल्सो कवर?
Sir, like as I said, one of the key elements is to be an abettor, you need to have knowledge. I think most critical element is आपको पता होना चाहिए कि एक तरीके से यहाँ बेनामी हो रहा है, because the underlying transaction which you explain can definitely come under the aspect of Benami, because this is being done in a way to defraud the creditor. Because जैसे आपने बताया कि जो प्रॉपर्टी है वो through some of my relatives, effectively I am trying to take it back for a lesser consideration, etc. In this process,
एनपीए अकाउंट्स में ऐसा ही होता है ना, जो सेटलमेंट्स होते हैं ऐसे ही होता है जब ऑक्शन
Correct.
करवाते हैं, तो ये
Correct.
दिस इज अ
So
प्रोसेस.
effectively, this is an arrangement to defraud the bank or the creditor here.
ओके,
So as such, इसमें element of Benami तो आ सकता है. Now question is, people who are involved, otherwise involved as a professional, let us say in the transaction, who are carrying it out, how far you have knowledge about this arrangement is a very important thing. So I'm just saying, it means that we have to be very cautious. We have to put in certain checks. We have to take certain declarations and all that to ultimately show that even if something like that has happened, which is beyond your knowledge, you cannot be alleged to be a अबेटर। बट अगर कोई ऐसा एविडेंस निकलता है कि जिसमें एक्टिव इन्वॉल्वमेंट आफ्टर नोइंग, एंड इन इन सम एक्सट्रीम केसेस ऐसे आता है कि कोई प्रोफेशनल ने ही एडवाइस किया है कि टू ओवरकम दिस यू डू लाइक दिस, then तो there is always a possibility of somebody being, even a professional being seen as a better here.
Okay.
The next query, sir. More aspect of the same query of CS Bajanji. What is the meaning of provided? Will loan it cover loan also?
Sir, as Mahinder explained, a loan which is actually a loan is not a problem. But many times we have seen the flow of money is sort of characterized as a loan, but the real intent is to give the money as a consideration. So if it is proved that the loan is sham and there was no intention to borrow money and then repay it, etc., then even the loan can be, actually it's a consideration camouflaged as a loan.
सर एक और क्वेश्चन है। सर एक जैसे अभी मैंने जो फर्स्ट क्वेश्चन रेज किया था उसमें ये था कि यूजुअली क्या हो रहा है, प्रैक्टिस किया है रियल एस्टेट में कि सपोज ए बाइज ए हाउस इन द नेम ऑफ बी और सी, ठीक है सर, उसमें ठीक है लिम्स अगर सेटिस्फाई होते हैं उसके फ्यूचर इमीडिएट बेनिफिट के लिए कंसिडरेशन पेड बाय ए फॉर परचेजर बी, ठीक है सर, और बेनिफिट ए को मिलेगा। बट बेनिफिट है ना जो सर, जैसे हम बेनिफिट देखते हैं, मान लो रेंट है वो सारा कुछ पहले ही मैनिपुलेट करके मान लो बी के नेम पे सब कुछ करवा दिया, इवन प्रॉपर्टी टैक्स है, इवन इलेक्ट्रिसिटी, सब कुछ उसके नेम पे है, और कंसिडरेशन जो बुक्स में या एक्चुअल में वो उसको आ रही है, एक्चुअली वो क्या कर रहा है, कैश में ले रहा है। तो नॉर्मल ये प्रैक्टिस होती है, क्या ये प्रैक्टिस चैलेंज हो सकती है? मतलब कि ये बहुत प्रैक्टिस हो रही है सर प्रॉपर्टी रियल एस्टेट में, तो उसमें क्या वो सेफ है, चैलेंज किया जा सकता है डिपार्टमेंट को या नहीं? अगर डिपार्टमेंट कोई क्वेश्चन रेज करता है कि मान लो किसी से इंफॉर्मेशन मिल जाती है थर्ड पार्टी से, कोई कंप्लेंट कर देता है उस केस में कि हमारे जो कंसिडरेशन है, मान लो जो बी है उसकी कैपेसिटी नहीं है, उसकी रिटर्न ऑफ इनकम बहुत कम है, बट ऑन द ग्राउंड सर इसी पे क्या डिपार्टमेंट एक्शन ले सकता है या हमारे पास एस्केप रूट है?
तो देखिए, जो आपने बिल्कुल सही बात बोला कि जो बेनामीदार है, आई
नितिन,
थिंक इनवेरियबली इन मेनी ऑफ दीज केसेस we see that the capacity, the financial credibility of the Benamidar is always questioned. Like we have seen many cases where employees who are like hardly earning 10 lakh rupees, 12 lakh rupees in a year, if they are purchasing properties worth crores, etc., always it is such a matter of questioning. That is one of the starting points. Now, the cash aspect which you mentioned, according to me, it's a matter of investigation, it's a matter of evidence, it's a matter, and also there are statements which are recorded. Now we have come across cases where some of these people, either the benamidar, or in some cases even people who have facilitated transactions, have gone ahead and given statements, and those statements then can be used against the beneficial owner to say that you are the beneficial owner, so and so has given statements, and they have corroborated it with certain transactions, etc., which have happened. So according to me, to answer your question, whether there is a risk, definitely there is a risk, and the evidences ultimately in the form of documentary evidences, sometimes even the communication between the people over WhatsApp or
That may be the
or other
possibility.
things. So all these things are used. So we are definitely seeing those cases where such things are happening, and then it becomes a very, I would say, factual kind of a fight on the question of evidence, whether this case is proved or not.
प्रोबेबली सर ये सिबलिंग्स के केस में ज्यादा हो रहा है, क्योंकि उसमें जो टाइटल डीड्स है वो भी मान लो जिस जो बेनामीदार है उसके पास ही रखी जाती है ताकि प्रूव ना हो सके। जैसे आजकल रेड होती, सर्च होती है, तो उसमें बहुत सी प्रॉपर्टियां पकड़ी जाती हैं, तो लोग अलर्ट हो गए हैं। वो सिबलिंग्स के केस में ज्यादातर हो रहा है, वो मान लो भाई है या भाभी है तो उसके पास ही रजिस्ट्री रखी जाती है, भैया आपके पास ही है। तो मैं ये देख रहा था स्केप रूट ले रहे हैं लोग, तो क्या ये जेन्युइन है? मतलब मेरा क्वेश्चन यही था बस।
सर भंडारी साहब, सिबलिंग वाले केस तो इसमें आते ही नहीं है।
हाँ, सिबलिंग्स का
सिबलिंग
केस तो
वाले तो
एक्सेप्शन।
केस ही नहीं आते इसमें।
नहीं
बिना
सिबलिंग सर, सिबलिंग अगर जॉइंट नेम पे हो फिर तो मतलब कि फिर एस्केप रूट है। अगर जॉइंट नेम पे नहीं है, मैं वो बात कर रहा हूँ सर, सिबलिंग तो आएंगे ना सर, अगर जॉइंट नेम पे नहीं है तो फिर तो बेनामी में आएंगे ना, कवर होएंगे ना सर, अगर जॉइंट नेम पे नहीं है। मतलब मैंने अपनी भाभी के नाम पे, मैं एग्जांपल दे रहा हूँ, अपने भाभी के नाम पे प्रॉपर्टी ले ली, ठीक है ना सर, पेड मैंने किया, रजिस्ट्री उसके पास पड़ी है, सब कुछ उसके
सिबलिंग
नेम
में
पे ही
नहीं
है।
आते, भाभी सिबलिंग में नहीं है
नहीं मतलब
उसमें।
सिबलिंग इन द सेंस में रिलेटिव्स में आ गई, बेनामी में तो आ गई ना।
ठीक है, चलो भंडारी साहब, मिस्टर
नेक्स्ट
जसविंदर
जी आप।
has also raised his hand, and thereafter I'll take the points. So let's unmute Jasminder Singh. Yeah, start it. CA Jasminder Singh.
हाँ जी सर, गुड इवनिंग जी सर, बहुत बढ़िया प्रेजेंटेशन रही प्रोग्राम। सर ये बताएं, इसमें कोई बेनामी में लिमिटेशन का कहीं कोई पीरियड आता है या कहाँ से आता है या नहीं आता?
सर इसमें एज सच कोई लिमिटेशन तो नहीं है सर। नाउ जनरली इसमें क्या होता है कि द ट्रिकी पार्ट अकॉर्डिंग टू मी इज इसमें क्रिमिनल एंगल भी है। नाउ under the like other laws, we have seen that where there is no limitation prescribed, the courts have said that some kind of a reasonable time limit should be read into it. But at the same time, when it comes to certain criminal aspects, now we have seen that there are situations where even without any limitation, actions can be taken. Now यहाँ पे वो दोनों का मिक्स है। बेनामी में आपका सिविल साइड भी है और क्रिमिनल साइड भी है। और दूसरा एस्पेक्ट ये है कि जैसे मैंने बताया, विच इज सब्जेक्ट मैटर ऑफ डिबेट एज ऑफ नाउ, ऑन द कंटिन्यूइंग नेचर ऑफ certain offenses. Now, typically, we have seen that when the action is taken, some element of the Benami transaction may be still continuing. So how to calculate, even if somebody has to argue on the reasonable time from what point of you have to calculate, etc., is very open. To answer your question, there is no limitation period which is prescribed here. So effectively, the officer can come and look at a transaction which has taken place, say, even 10 years ago, and then he
नो
can
सर,
actually look at it.
मेरा थोड़ा सा मोर देन 10 years है, लेकिन उसमें बेटा बोलना, उसमें इशू ये है कि 10 महीने से केस खुला, 2022 में 10वें महीने से।
Okay.
और उसके बाद हमने सारी रिप्रेजेंटेशन दे दी, डिपार्टमेंट ने फॉलो अप नहीं किया। हमने 2 4 6 बार करा तो उनके पास कोई एविडेंस नहीं निकला। उसके बाद इनकम टैक्स के केस खुल गए। इनकम टैक्स के केस पहले 1 खुला, फिर 2 और खुले, फिर 5 और खुल गए। मतलब टोटल 7 8 साल हो गए। अभी सारे के सारे सेटल हो गए, लेकिन वो सेटल होने के बाद भी ये वाला डंडा ऐसे ही लटक रहा है, कुछ पता ही नहीं, निकला कुछ भी नहीं। तो यहाँ पर जैसे 2022 के बाद बेनामी वाले डिपार्टमेंट से कोई भी कॉरेस्पॉन्डेंस नहीं हुई।
Understand.
तो इन दैट केस रीजनेबल पीरियड कहाँ तक या कैसे, हाउ कैन वी अज्यूम? क्योंकि क्लाइंट के लिए तो हम ही है ना, वो तो डिपार्टमेंट को जानता नहीं। और हमारे जितनी देर तक हमें डिपार्टमेंट से कुछ ना मिले, हम क्लाइंट को कैसे जवाब दें?
सर मैं ये कहूंगा कि इसमें कोई ऐसा हार्ड एंड फास्ट रूल नहीं है, बट अगर मान लीजिए काफी डिले के बाद आता है, मतलब मैं ये कहूंगा कि अगर ऐसे सिचुएशन में, एक एग्जांपल लेता हूं कि मान लीजिए 5 साल के बाद दोबारा अगर आपके आपके डिपार्टमेंट नोटिस इश्यू करना शुरू करते हैं, then I think we may have a case to, for example, challenge it in a repetition before a court and say that already it was investigated not only by them from a Benami angle but from income tax angle. All of it has been cleared. Now, because क्या होता है कि जब ट्रांजैक्शन के बाद टाइम पीरियड लैप्स करता है, इवन फॉर द असेसी टू मेंटेन ऑल द रिकॉर्ड्स। सो आपने पहले पूछा, मैंने आपको सेटिस्फाई कर दिया। Again, if you come and ask me, and suppose I have not retained those documents in the regular course, it is very difficult for me to again come back and submit all the details, etc. So that is also a reason why limitation should be written, reasonable period should be written. So in my view, if we find that, say, for instance, जो 2022 में आपका सारा हुआ था, another
3 साल हो गए पूरे दिसंबर
मान
में।
लीजिए अगर दो साल के बाद और आते हैं, मेरे हिसाब से उसी स्टेज पे हाई कोर्ट में इसको चैलेंज करके वी कैन से दैट। अच्छा, इसमें एक और चीज सर ये आपको ध्यान रखना पड़ेगा कि क्या वो उसी इंफॉर्मेशन, उसी मटेरियल के बेसिस पे इन्वेस्टिगेशन दोबारा चालू कर रहे हैं या कुछ नया चीज उनको उनको मिला है। बिकॉज समटाइम्स द कोर्ट ऑल्सो takes it into account. Suppose it's all based on the existing material, there's nothing new. Then
सर
we are,
एक साल जैसे खुला था, उसके बाद 2 साल और खुले, फिर 3 साल और खुल गए। तो बेसिकली जो बेनामी वालों ने निकाला था उसमें तो कुछ मिला ही नहीं।
हाँ,
बाकी के जो केस खुले उसमें उन्होंने जो पूछा सारा कुछ सेटिस्फाई होके खत्म हो गया। अभी कुछ फ्रेश ग्राउंड नहीं है, बट क्लाइंट एक्सपेक्ट्स के भी हम उसको कुछ जवाब दें कि भी केस खत्म हुआ कि नहीं हुआ। तो अब
नहीं
तीन
सर, आई
तीन
थिंक
साल के
सर जहां तक क्लाइंट को जवाब देने का है, मतलब मैं तो सिंपली कहूंगा कि you today you have no basis now, unfortunately there is no concept of the officer giving you a closure report.
हाँ, तो यही प्रॉब्लम है
वो तो देते नहीं है ये लोग, और अभी जाके बोलना भी जो है वो
सर।
अननेसेसरी।
वो तो आप बैल मुझे मार।
तो मैं तो ये कहूंगा कि आप क्लाइंट को ये बोल सकते हैं कि अभी तक और कुछ नहीं है, तो वी हैव टू वेट। अगर इसके बाद मान लीजिए 1-2 साल के बाद अगर वो डिलेड बेसिस पे आते हैं, देन वी हैव टू लीगली चैलेंज इट, बिकॉज लॉ में ऐसा कोई हार्ड एंड फास्ट वो नहीं है। दैट्स व्हाई कोर्ट विल गो ऑन अ केस टू केस बेसिस।
चलिए सर, ये बताएं, जैसे हमारे पास क्लोजर रिपोर्ट डिपार्टमेंट से, इनकम टैक्स से आ गई,
हाँ,
तो उसको अगर बेनामी में कुछ हो तो दैट कैन बी फाइल्ड कोर्ट में जाने से पहले कि जी ये हमारा हुआ था, तो उसमें तो कुछ नहीं निकला, दैट इज
बिल्कुल
ओके।
बिल्कुल, बिकॉज
अदरवाइज वी शुड कीप क्वाइट।
करेक्ट, अल्टीमेटली though they are operating under two different laws but the same department, so what satisfied the authorities under income tax law is good enough for Benami also.
Yes, Mr. Rajesh Jindal.
थैंक यू सर।
गुड इवनिंग सर।
Good evening, sir.
सर मैं ये क्वेश्चन पूछना चाह रहा हूँ कि मिस्टर ए ने प्रॉपर्टी मिस्टर बी को बेची, लेकिन टाइटल डीड एग्जीक्यूट नहीं हुई, तो ये प्रॉपर्टी इन बेनामी डेफिनेशन में कवर होती है सर, टू माय माइंड। लेकिन मेरा सवाल ये है कि यदि बी उस प्रॉपर्टी को सी को बेच देता है, वहां टाइटल डीड एग्जीक्यूट हो जाती है, वो टाइटल डीड या तो ए एग्जीक्यूट करता है या बी ऑन द बेसिस ऑफ पावर टर्नी फ्रॉम ए एग्जीक्यूट करता है, तो क्या ये प्रॉपर्टी स्टिल बेनामी में फॉल करती रहेगी फॉर एवर, या ये निकल गई बाहर सर?
सर मतलब जो आपने स्टेटमेंट बोला कि जो पहला ट्रांसैक्शन है, आप एक मिनट के लिए मान रहे हैं कि वो बेनामी है।
जब तक वो टाइटल एग्जीक्यूट नहीं होती बी के नाम पे, वो बेनामी है सर।
सर मैं बस ये बोल रहा हूँ कि मैं अभी के लिए मान रहा हूँ कि
जी।
आपका जो स्टेटमेंट है वो ठीक है, बिकॉज आई डोंट वांट टू चेंज द फैक्ट्स। जो आपने फैक्ट्स बताया मैं एक मिनट ले लेता हूँ। अगर मान लीजिए पहले लेग पे ट्रांसैक्शन प्रॉपर्टी बेनामी है, मतलब ट्रांसैक्शन बेनामी है, जो सेकंड लेग जब हो रहा है, दैट इज व्हेन बी इज फर्दर सेलिंग टू सी, तो क्वेश्चन ये आएगा कि जो सी है क्या वो बोनाफाइड परचेजर क्वालिफाई करेंगे नहीं करेंगे। तो एक एस्पेक्ट ये आएगा कि पहली बात तो कब हो रहा है ट्रांसैक्शन। अगर ये 24/1 का नोटिस से पहले ट्रांसैक्शन हो रहा है बिटवीन बी एंड सी, सेकंड सी शुड बी टोटली अनअवेयर ऑफ द फर्स्ट लेग, दैट इज उनको नॉलेज नहीं होना चाहिए कि वहां पे कोई बेनामी का एस्पेक्ट है। इन दैट केस द सब्सिक्वेंट ट्रांसफर सी का जो इंटरेस्ट है वो प्रोटेक्ट हो जाएगा। अदरवाइज यू आर राइट दैट द प्रॉपर्टी एज सच कंटिन्यूज टू बी अ बेनामी प्रॉपर्टी। इनफैक्ट वी आर फेसिंग सच केसेस वेयर हमारा परचेज इज परफेक्टली ऑल राइट, बट आवर सेलर, उनका जो अरेंजमेंट था वहां पे वो लोग अलज कर रहे हैं कि वो बेनामी है, देन द प्रॉपर्टी इज अटैच्ड फ्रॉम माय हैंड्स। वी आर एक्चुअली having that case in our hands, and then the onus is shifting on to us to show that we didn't have any knowledge and all that.
तो इसमें दो एस्पेक्ट आते हैं। एक आपने वर्ड यूज किया जो नोटिस इशू से पहले जो ट्रांसफर होती है या बाद में इशू होती है। यदि नोटिस कभी भी आया नहीं है, उससे पहले सी के नाम पे टाइटल डीड हो जाती है, तो क्या अभी भी ये बेनामी है सर?
Sir, it may be technically benami, but you also get protection as a bona fide purchaser.
नहीं, बोनाफाइड परचेजर का तो मैं बेनिफिट ले ही नहीं पाऊंगा सर, क्योंकि मैं प्रॉपर्टी बी से परचेज कर रहा हूँ, रजिस्ट्री या तो ए करा रहा है या बी ऑन काउंट ऑफ पावर टर्नी फ्रॉम ए करा रहा है, तो इट ऑलवेज बी इन द नॉलेज ऑफ सी के ये बीच में कुछ गड़बड़ है सर।
नहीं सर, मैं इसलिए मैंने बोला जस्ट बिकॉज बी इज होल्डिंग ए पावर ऑफ अटॉर्नी, ये जरूरी नहीं है कि ऑलवेज इट विल बी ए बेनामी, बिकॉज बेनामी के जो एलिमेंट्स हैं वो सेटिस्फाई हुए नहीं हुए, दैट मे नॉट बी इन द नॉलेज ऑफ सी।
मैं करता
तो मेरा ये कहना था कि प्रॉपर्टी को बेनामी bolna is one thing, but what recourse can be taken against C is another aspect. So C can defend saying that भले ही पहला ट्रांजैक्शन में कुछ बेनामी एलिमेंट हो, वो मेरे नॉलेज में नहीं है, मैंने प्रॉपर कंसिडरेशन दिया है और बी ने मेरे को प्रोजेक्ट किया है कि he has all the rights to sell this property to me, whether in his own capacity or in the capacity of a power of attorney holder. So if all that is there, I think C can definitely claim this protection.
सर इसको फर्दर मैं इसको एलैबोरेट करना चाह रहा हूँ ऑन द पर्सपेक्टिव ऑफ बी, क्योंकि ये कहा गया है कि प्रोसीड्स ऑफ द बेनामी प्रॉपर्टी इज आल्सो बेनामी प्रॉपर्टी, टू दैट एक्सटेंट इट इज ओके. नाउ इन द हैंड्स ऑफ सी, when the proceeds of the property in the hands of B is recoverable and attachable, and it is attached, since then property in the hands of C is also benami.
सर ये जो एस्पेक्ट है कि मतलब मैं इसको ऐसे ऐसे बोलूंगा कि जो डेफिनेशन है प्रॉपर्टी एंड देन बेनामी प्रॉपर्टी का, ये ऐसा नहीं है कि वंस द प्रॉपर्टी हैज बीन ट्रांसफर्ड that property ceases to be Benami property, only you can go after proceeds. ऐसा नहीं है. It is like first Benami property, अगर वो Benami property traceable है, they can go after it. As an alternate, they also have other things. Now, what will happen? Like the way I would look at this case, if I have to frame a case is, if I find that जो C को transfer हुआ है, C is a bona fide purchaser, then I may not be able to attach that property. Then I will say, okay, money came to B. Where is that money lying? Where is that money getting converted? With that money, some other property has been purchased, I will go after that property. Or if that money is lying in a bank account, I will go and attach bank account. So, as an investigator, that is what he's supposed to do. He is supposed to apply his mind and see what is the capacity in which C has acted. If he is a bona fide purchaser, then he should actually go after the proceeds of the sale proceeds.
No. What I want to ask here, sir, whether both the properties are Benami, property proceeds of the property in the hands of B and property in the hands of C itself with bona fide is not proved. Both the properties are Benami, sir, or the only proceeds, either proceeds or the property in the hands of C will be Benami?
Sir, technically definition के हिसाब से दोनों can be Benami.
Okay. तो यहाँ पे काइंडली कैन यू एक्सप्लेन जो सी राजेश जी का फर्स्ट लिंब है, फैक्ट है कि जो उन्होंने पावर ऑफ अटॉर्नी दी है और एग्रीमेंट टू सेल कर लिया, बी को ओन कर दिया, तो ही इज सेइंग दैट इट इज ए बिनामी प्रॉपर्टी. इन विच सर्कमस्टांसेस सच टाइप ऑफ ट्रांजैक्शंस कैन बी बिनामी? ए लिटिल ओवरव्यू ऑफ दैट, सर.
Like just to take a simple example, when B is holding the power of attorney and then he is, let us say, now the possession, let us say, of the property has been given to B, and B is holding a power of attorney, he is now having it. Suppose the property is being fully enjoyed by B, any future benefit from the property is also going to be with B only. Then the second limb of the definition of Benami is not satisfied. So B will say that even though the property is still in the name of A and I'm holding a power of attorney, when the transaction happened between A and B to execute the power of attorney, etc., the transaction was actually to pass on the benefit to B. So it is not as if B is a name lender or A is a name lender in this transaction. So both the limbs have to be satisfied.
सर इस केस में सेक्शन 53 में ट्रांसफर प्रॉपर्टी एक्ट में जैसे जिस सर ने कहा कि A to B, B to C, अब B ने सर एग्रीमेंट है या पावर टोनी, तो पावर टोनी के बेस पे अगर वो C को बेचता है तो वो तो टाइटल ही सर रिवोक हो जाएगा. वो तो एज पर सुप्रीम कोर्ट की जजमेंट आई है मनुजा केस में समथिंग में 2025 में ना भी, कि जब आप पावर टोनी के बेस पे जनरल और एग्रीमेंट के बेस पे आप टाइटल डीड के ऑनर नहीं हो सकते हो, तो उसमें फिर बेनामी क्या कैसे बनेगा सर?
So yes, so there is also an basically explanation under the law.
जी.
All the transactions which are basically referred to under section 53A of the Transfer Property Act, they will be excluded from the ambit of the Benami transaction. So that exclusion has been provided in the law itself.
Sir, ये law सर ये कोई लॉ में चेंज हुआ? क्योंकि इनिशियली अभी रिसेंटली मैंने नहीं देखा, जो इनिशियली लॉ आया था उसमें एक राइडर और था कि 53A की ट्रांजेक्शन वो बेनामी से बाहर होंगी जहां पे इसको रजिस्टर करा लिया होगा। टाइटल डीड नहीं
Yes,
होगा लेकिन
yes,
एग्रीमेंट
yes,
रजिस्टर
yes,
करा लिया होगा।
इवन
yes.
पावर टोनी भी इसमें कवर नहीं होगी।
And
सिंपल।
53A, sir, under the Transfer Property Act, there is a requirement for registration. So if you are qualifying under 53A part performance, also it is registered there, then only you will get this benefit.
Yes.
Sir, the prevailing practice is consideration is passed from B to A, possession is given by A to B. There is a full and final agreement and a power attorney from A to B. This transaction satisfies for the Benami transaction, sir?
The
Possession transfer from A to B, consideration transfer from B to A, power attorney from A to B, and a full and final agree from A to B.
Seems to be.
This is the Benami transaction.
So as per the explanation, the consideration that should be provided, ownership must remain with the person, stamp duty has to be paid, and the contract is required to be registered. If all
Yes, sir.
these conditions are satisfied, then the transaction will be excluded from the ambit of definition of Benami transaction.
So, for the sake of knowledge, I just want to know what is the difference between the registration of this agreement and the execution of title deed.
The execution of title deed, when it will happen, then the conveyance, that is in the revenue records, the ownership itself is changed to
In the
person.
revenue record.
In
क्योंकि
part
टाइटल ही नहीं
performance,
क्लियर है सर, अगर प्रॉपर्टी एक्ट में टाइटल ही क्लियर नहीं है आपके पास तो फिर बेनामी का तो सवाल ही पैदा नहीं होता। द टाइटल इज नॉट ट्रांसफर्ड।
तो
the-
नॉर्मली may I add, नॉर्मली जो पावर टर्नी होती है ना उसमें इट इज मेंशन देयर कि दैट पर्सन कैन ओनली डू दी, इसको ट्रांसफर कर सकता है, ही कैन ट्रांसफर इन द अदर नेम, वो करता है। वहां पर जो पेमेंट का क्लोज है वो नहीं ज्यादा लिखा होता कि वो जो भंडारी सर कह रहे हैं ना कि वो इंटाइटल नहीं है, वो सुप्रीम कोर्ट वाला, वो तो आपको पावर टर्नी रजिस्टर होने लग गई है। जो हम लोग नॉर्मली पावर टर्नी कराते हैं 500-700 रुपए स्टैम्प पेपर पर, दैट इज इट इज वेरी फ्रॉम स्टेट टू स्टेट। पंजाब में आप 2% ड्यूटी दो, पावर टर्नी रजिस्टर होती है तहसीलदार के पास, रजिस्ट्रार के पास। जो हम वेरी करते हैं वो दैट इज नॉट चैलेंजेबल। जो सुप्रीम कोर्ट आप कह रहे हो, आई थिंक सो कि वो जो सुप्रीम कोर्ट का इशू है, और उसमें पेमेंट का क्लोज नहीं लिखा होता। बट प्रॉब्लम क्या यहाँ पर क्या है कि वो इकरारनामा और वो साथ में रखते हैं लोग, मुख्तियारनामा इकरारनामा, इन दी लोकल टर्म सर इट इज कॉल्ड इकरारनामा मुख्तियारनामा। तो वो उस बेस पर वो क्या कहते हैं, पेमेंट ले लेते हैं। अब इशू आ जाता है कि समाओ जैसे कुछ पर्सन क्या होता है वो अपने प्रोफेशनल से डिस्कस कर लेते हैं, तो देन हम डेफिनेटली उनको मना करते हैं कि पेमेंट शुड गिवन इन द नेम ऑफ द ओरिजिनल सेलर हुज नेम इज मेंशन इन द रजिस्ट्री, क्योंकि उसका नाम ही आएगा। पावर टर्नी जैसे आई एम रिप्रेजेंटिंग योर केस, अगर आपको कोई कुछ भी होता है वो आपके ऊपर है, मेरे ऊपर नहीं है। आप पर कोई कैपिटल पनिशमेंट लग जाती है, जेल आपने जाना है, आपके एडवोकेट या उसने नहीं जाना है। आपको टैक्स लगना, आपको लगना है, भंडारी साहब को या मुझको नहीं लगना। तो वो इशू है। पर आज जो पेमेंट पावर टर्नी होल्डर अपने नाम पर डाल लेते हैं, कई बार वो पेमेंट का क्लोज भी पावर टर्नी में चेंज करवा लेते हैं कि पेमेंट, वो भी पेमेंट भी ले सकता है। वो वही करते हैं ज्यादातर जिन्होंने प्रॉपर्टी पहले परचेज कर ली होती है, और वो कर लेते हैं। इस केस में सर तो जो बेनामी के साथ साथ जो बायर है उसके ऊपर क्या इशू आ जाएंगे? भंडारी साहब के हिसाब से तो प्रॉपर्टी इनएलिजिबल बार बार कह रहे हैं, जैसे भंडारी साहब, वो भी एक इशू है बड़ा बड़ा। और आपके हिसाब से वो क्या, उसके ऊपर कितना मतलब इफेक्ट आएगा सर बायर के ऊपर? वो उसको तो कोई कई बार नहीं पता होता। ये मेरे पर केस है, मान लो ए पर।
ठंड साहब बात ऐसे है कि ये जो है कंसिडरेशन की बात है। इफ कंसिडरेशन इज गिवन फ्रॉम द नोन सोर्सेस, ओके, and that is the power of attorney and the agreement to sell is there, that the person will, if it has genuinely passed, then there is no question of Benami transactions.
Okay.
And if these are not legitimately passed, and the other person is transferring the other's name just without giving any consideration, then it is a Benami transactions, transferring the property on the other's name. That is the Benami. And if the proper consideration is there, then it's not become the Benami transaction, whether it is registered or unregistered.
टिपिकली जो 53A वाला जो हमने एग्जांपल लिया था,
he has 53 transfer of
डेवलपर वाला
property.
अरेंजमेंट जो होता है,
हाँ जी.
जॉइंट डेवलपमेंट अरेंजमेंट में या
Yes,
डेवलपर अरेंजमेंट
yes.
होता है, उसमें it is very often
It-
done, and
जी
as sir
No.
said, the
हाँ जी.
consideration is paid, and thereafter the developer gets the entire right over that property.
Right.
Even though the conveyance may happen at the end.
सर
Right.
सर इस
बट
केस
सर
में
काइंडली सर मैं एक छोटा सा ऐड करना चाहूंगा यहाँ पे कि जो 53 का एक्सक्लूजन है, दैट इज ओनली इन द एक्सप्लेनेशन, दैट इज ओनली टू डिस्पेल सम कंफ्यूजन्स unless and until a transaction is not coming into the definition of the Benami, just like as the sir has elaborated. तो आई थिंक सो उसके बाद तो हमें रजिस्ट्रेशन या नॉन रजिस्ट्रेशन देखने की जरूरत नहीं है. That is only to dispel some confusions in such transactions which are otherwise coming into the Benami color as per their definition. Then they may get excluded by virtue of these explanation. My humble submission. Well, it is not a charging explanation. Explanation is not charging for the Benami transaction.
Absolutely.
ये तो वैलिडिटी चैलेंज कर रहे हैं बस.
Right. Deepak ji, please sum up, please. I
जी,
think.
जी. Now I request, sir, I request CA Sanjeev Bhandari ji, our worthy Vice President, to have concluding remarks. And
Thank
vote
you,
of thanks.
Deepak ji.
Bhandari ji.
Thank you, Deepak ji. Good evening, all. Respective present, sir. Past present, C. Jasminder ji, Swajan ji, and other dignitaries. Worthy speaker, Advocate S. Vasudevan ji and his team. And acknowledge also its Vice Chairman Rajesh Mahajan ji and their team, and ITPA Parivar Amritsar. So, sir, it was really indeed an interactive and deliberating section, and you have demonstrated very well, because it is a very touching and hot topic, and I think in future many cases are on the radar of the department. As far as businesses, NPA accounts are concerned, more and more accounts are becoming NPA, and real estate just like booming, and more projects are coming. They are lucrating the investors to buy more and more properties and diverting their funds to the real estate, and that's why they are making purchases of more and more properties in their relatives' names. So in future, I think it's a very good topic, and members should be aware of that. And you have demonstrated very well and in a very simple and clear language, which has helped all the members in understanding this very important topic. So I extend my heartiest gratitude to sir and your colleague. And I also extend my sincere thanks to the DTV Parvar for making this seminar very interactive and huge success. And I also extend my special thanks to the study circle team, conveners here, J. Janji in absentia, and his technical team for providing support for the technical part. I also extend to my sincere thanks to the all the executive members. Thank you once again. And if I hand over the mic to Deepak ji.
Thank you, Bhandari ji. Thank you, Vasudevan ji, for such a beautiful, elaborated deliberation, sir. Now the dice is open for all the members to have some discussions, informal. And my sir, President sir, wish to say something, I think so.
Thank you, Vasudevan sir. It's wonderful. And I ask the present here to give a good applause to the. Thank you, sir, very much.
Unmute itself. I have changed the setting. Every member can unmute himself or herself.
Thank you, sir.
Thank you, sir. Thank you. Now, sir, to close or have some informal discussion among the members.
हाँ जी, बोलो जसविंदर जी.
हाँ जी सर, प्लीज अनम्यूट कीजिए सर. मैंने सभी को अलाउ कर दिया है. काइंडली आप अनम्यूट कर लीजिए. जी आप कीजिए सर.
हाँ जी, बोलो
जी.
बोलो जसविंदर जी.
हाँ जी सर, बस सर बड़ा ਵਧੀਆ ਸੈਸ਼ਨ ਲੱਗ ਗਿਆ. ਹੈਲੋ
हाँ जी हाँ जी
ਜੀ ਸਰ।
ਹਾਂ ਬੜਾ ਵਧੀਆ ਸੈਸ਼ਨ ਲੱਗ ਗਿਆ ਤੇ ਉਹ ਮੇਰੇ ਖਿਆਲ ਤੁਸੀਂ ਰਿਕਾਰਡਿੰਗ ਜਿਹੜੀ ਹੈ ਉਹ ਬੰਦ ਕਰ ਦਿਓ ਜੇ ਆਪਾਂ ਇਨਫੋਰਮਲ ਡਿਸਕਸ਼ਨ ਕਰਨੀ ਹੈ।
ਜੀ 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 ਪਲੀਜ਼ ਸਰ।